there's a number of aspects. The biggest one, if we pick up on that idea of it being a little bit of a messy structure, is that ideally, if there can be some sort of corporate entity that's the face to the outside world, that we see that being used very, very regularly. Now, whether that's a standalone sort of nominee or agent type of company that's appointed to act on behalf of all the trusts, or whether in fact you just have one company acting as trustee for all of the trusts is probably a moot point. That the outcome that's delivered to the outside world is that they're not having to deal with numerous separate trusts. As far as the clients that are engaged, they all they see is that standalone Pty Ltd company. So that would probably be the biggest thing. The other types of things that need to be thought about, I guess, are looking at the constitution of that company and making sure that you've got appropriate balance between directorship powers and shareholder powers. You'd also obviously, well, particularly if you're going to use the same company as trustee for a number of trusts, need to have a fairly good understanding of how appointor or principal or nominator type powers under the trust documents work, to give everyone the comfort of knowing that they do have ultimate say over their particular trust, in inverted commas. Probably the final point would be, and this harks back, we've got some themes coming through here, this harks back to this concept of asset protection, that if you're serious about maintaining protection against issues that might go wrong in the practice, it would really be quite important, in our view, that the trust that is involved as a partner in the partnership of trusts do nothing else but be a partner in that trust. So in other words, you don't buy the investment property in the trust, you don't have the listed share portfolio in that trust, because otherwise you're potentially exposing all those personal assets to the risks of the business.